Welcome to the PatentBeast podcast. Today's topic poses a big question. Should IP attorney use AI? What every investor should know.
Because this is a pretty big
topic. So some people think that AI is terrible and shouldn't use it, especially in intellectual property for lots of reasons we can get into. And some people think it's terrific. In fact, recently, I would say in the last 2 or 3 months, we've received 5 or 6 applications that were written by clients or potential clients, and they send it to us and say, here, take a look at it, change it and file it and so forth. And it can be a big help. It's not necessarily bad. And in some cases, it's quite good.
Right.
So I want to go through those things and say what's good and what's not good about it. The first thing to know is that AI amplifies the skill of the person using it. If you're not that good at understanding how to write a decent patent application, it will write a pretty awful patent application.
Right.
And why is that? Well, if you think about writing a patent application, you're dealing with prior art searching, you're dealing with writing the specifications, and you're dealing with writing the claims. Right. And with respect to the prior art searches, AI is amazing. It can find all sorts of things, not only at the patent office, but also what we call non-patent literature.
Right.
Things that you could never find on your own.
That's
so it's just amazing. On the other hand, it will take that information and write claims which have a problem for many reasons. One reason is it will come up with claims that are just unpatentable. And it's unpatentable for various reasons. For example, let's say, I think we mentioned this in a prior podcast. Let's say the claim requires a doctor to do something and a patient to do something.
Correct.
So no one infringes, because to infringe, it has to have a single entity that does both things. The other thing it will do is it will put, in order to get claims that are allowable, AI will put in all sorts of limitations which are not necessary. If they're not necessary for patentability, they shouldn't be in the claim.
Absolutely.
The other thing it will do is it will write a specification that doesn't actually support the claims. If it doesn't support the claims, it's not enabling, it's not sufficient. Another problem is that it will write claims with elements, and then you have drawing, and the drawing does not include all of the elements. If you're going to have an apparatus claim, I've got a device and it has A, B, C, D, and E, there better be a picture, there better be a drawing with A, B, C, D, and E, or you can't do it. So bottom line is that AI is good at drafting. It's brilliant at drafting, but it's not good at strategy.
Correct.
And so it has good function, and we use AI in our practice, right? But you can't rely on it to do the job.
Right.
Not sufficient.
You need a human touch and expertise.
Yeah.
So
another thing it's not good at is obviousness. So to get a patent application or a patent, you need new, useful, and non-obvious as the subject matter. New is usually pretty easy because no one's done exactly what you're claiming. Useful is pretty easy because if it wasn't useful, why would you bother patenting it? The problem is obviousness. And AI is very good at saying, here's what we're claiming, someone else has done the same thing. But it's not good at saying, and this reference shows this and this one, and you put them all together, and what you're saying is now obvious. So it's not good at that. The other thing we found it's really bad at is what's called 101. It's a subject matter eligibility. And that has to do with, goes all the way back to 2014 with Alice versus CLS Bank.
Talked about that.
Right, where the Supreme Court said you can't patent something that's a mere idea unless there's something significantly more. But the court didn't say how you know what's an idea, where's the line, and how you know what's significantly more. And so humans have trouble with that, let alone AI. So it just doesn't do a good job with that.
I agree with that. What else would you say?
The other thing is that allowability, that is, can you get your claim past the patent office, is not the same as enforceability. And I talked about that for just a minute, right? So let's say you claim something, a way of manufacturing a computer chip, right? Well, someone manufactures the computer chip, let's say in Taiwan. Well, you have a patent in the United States on that. It's a patent infringement to bring it into the United States, but how would you know?
Right.
Are you going to go to Taiwan into their factory and see how they're doing it? They'll never
let you.
And I suppose in some countries you can have a court force certain things, but you're not going to get a court in Taiwan or Korea
It doesn't make sense.
to allow you to go in and see what they're doing in their factories. It's just not going to happen. We talked about unrelated actors. Sometimes a narrowly specified algorithm, and you can't, it's just too narrow. There's too many limitations to the claim. So yes, you get the claim issued, it's not enforceable.
Right.
Or it is enforceable, but it's easy to circumvent, right? Competitor will look at it and say, yeah, that's a great idea, but I'm just going to change this one thing a little bit. And AI is not good at that.
Right.
Not yet.
Not yet, but
Give it another 5 years, 2 years, 1 year, who knows?
It's changing quickly. Would you have any advice how to talk to, let's say, a new patent attorney you're just starting to work with and using AI? What should you be aware of? What should you ask them?
Yeah, because we've used AI also, and there's a learning curve to it. And the thing that I would recommend the most is be iterative, right? So you do a concept and you think that these claims might be allowable. And then you go to AI and say, can you find prior art against these? And it comes up with all sorts of things and you evaluate it. Okay, when we rewrite the claim, you then don't go from there to write the specification. You then say, well, now let's find prior art against that. Okay, now new claims, and you go over and over again until you find something that's allowable, or you think it's allowable, and then you say, how do we broaden the claim? Do we actually need element number 4? Could we do? And then you also have to go back and say, how else could you do this application? So this comes back to what I said before. The goal is not to patent the invention. People think that's the goal. That's not the goal. The goal is, what do you want to stop competitors from doing, right? So here's a technology, here's what you're trying to accomplish, make something more energy efficient, make it faster, better, cheaper, whatever it is. You have a way of doing it, right? So you're going to get a little piece of the marketplace. But if your little piece is too little, it's not really worth anything, because people will do other things. So the goal of a patent is to try to get a mini monopoly. So what you have to figure out is, how else could people do this? So when you get done with this whole process, what a good patent attorney will do is say, okay, here's we can claim for what you invented, we broadened it out. How else could you do this? Let's brainstorm it. And you can try to brainstorm with AI, but it's some problems and hallucinates like crazy.
A lot of people don't even fully understand, but it actually hallucinates a lot. So you have to be very aware of it.
There was just a case that came up this morning that's actually going forward. It's Google. Did you read about that one?
No, but tell me about it.
Someone claimed, can't remember the details, but someone filed a complaint based on allegations that they got from one of the AI. It said that someone had said something. And it turns out the AI made it up.
Oh, jeez,
So it's an allegation against someone defamatory. But the person never said it.
Wow.
And so it went to court, and the defendants, this is all nonsense, they were able to show somehow that AI made it up. But the court said, well, how do you know? At this stage in the case, maybe you can prove that, maybe you can't. But at this stage in the case, we're going to consider it to be accurate.
Wow.
So even though it was established that it was hallucination, it's still going forward in the case.
That's
so
wild,
it's a little scary.
That is very scary.
Anyway, so line, AI is fabulous. It will get more and more fabulous. We happy if people want to send us AI applications, and then we'll fix them up. Sometimes it's cheaper, sometimes it's more expensive. But it's a great thing to do with AI, to challenge yourself. And the other thing is that, I think I mentioned before, we turn away probably 30 to 40% of the applications that come to us, because I just can't charge someone for something, and I know darn well they're never going to get a good patent on this. It's not enforceable, or for whatever reason. And if I know that at the end, I will really try to push them and say, don't do the money, right? But they can do that themselves. Here's your idea. Tell AI the idea, whether it's ChatGPT or whatever. Is this idea patentable? And find prior art against it. Because people often come to us and say, oh, I know everything about this field. I know no one's ever done this before. And then you go to AI and say, has anyone done this? And it says, oh yeah, here's different times they've done it. Right. So that's the bottom line. Use AI. It's great. It's wonderful, but you can't rely on it.
I agree. Thank you so much,
Is that
Bob.
helpful?
Yeah, very helpful. Thank you for watching, and don't forget to subscribe, follow, and like us. See you next time.